Welcome, everybody, to an abbreviated version of the Tilted Lawyer podcast. This is Omar Serrato. This morning, we're going to be talking about Harvey Weinstein and why his conviction was overturned in New York and why it's a good thing as it protects those who rely upon the protections of the Constitution of the United States as it relates to claims brought against them. You're going to want to stick around for this one. Let's get started.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
So Harvey Weinstein is one of the most powerful figures to ever come out of Hollywood. He has amassed a Hall of Fame career with unparalleled credentials, a career that began in the early 70s, starting his company with his brother, using profits from a concert promotion business that he used to run. Him and his brother, they founded the independent film distribution company Miramax that was later purchased by Disney. It was named after their parents, Miriam and Max. The company's initial releases were primarily music-oriented concert films, such as Paul McCartney's road shows. But as you might be familiar, he is responsible for some of the most highest grossing films in American history. In the early 1980s, Miramax acquired the rights to British films of benefit shows filmed for human rights organization Amnesty International. He worked closely with Martin Lewis, who was the producer of those original films. The Weinstein brothers edited two more films into one tailored for the American market, and the resulting film was released as The Secret Policeman's Other Ball in May of 1982. And that was Miramax's first major hit that kind of put them on the map. Afterwards, they kind of took off from there. Harvey Weinstein and Miramax had gained wider attention in 1988 after releasing Errol Morris, which was a documentary, The Thin Blue Line, which detailed the struggle of Randall Dale Adams, a wrongfully convicted inmate sentenced to death row. The publicity that soon surrounded the case resulted in Adams being released, and nationwide publicity for Miramax. And in 1989, their successful launch release of Steven Soderbergh's Sex, Lies, and Videotape propelled Miramax to become the most successful independent studio in America. And after that, in the 1990s, they were just kind of all over the map, producing films such as The Crying Game, which was a psychological thriller of the kind that had not been seen up until that time, produced in 1992. Disney had offered, coincidentally after that time, to purchase Miramax for $80 million. They ended up agreeing to that deal. The following year, they released Quentin Tarantino's Pulp Fiction, and right after that, they were responsible or helped distribute the popular independent film Clerks. If you're familiar with that film, back in 1994, 95-ish. They won their first Academy Award for Best Picture in 1997 with The English Patient. Pulp Fiction was nominated in 95, but ultimately a loss to Forrest Gump. And started a string of critical successes that included Good Will Hunting, Shakespeare in Love, both films receiving numerous awards and numerous Academy Awards. In 2005, Miramax kind of transformed into what is now known, or then known from until about 2017, the Weinstein Company. The brothers decided to leave Miramax. At that time, formed their own production company, along with several other media executives, including Quentin Tarantino, Robert Rodriguez, Colin Baines, and had successfully ran the production department at Miramax for 10 years. So in February of 2011, Michael Moore, he began taking legal action against the Weinstein brothers, claimed that they had owed him $2.7 million in profits for his documentary Fahrenheit 9/11, some of you might remember, which he said were denied to him by Hollywood accounting tricks, among other things. An analysis of Academy Award acceptance speeches from 1966 to 2016 found that Weinstein had been thanked or praised in 34 speeches, as many times as God, and second only to Steven Spielberg with 43 mentions, that coming straight from an article from, what is this from? New York City Quartz Media. So he's been around, and he's a very powerful person in Hollywood, or he was a very powerful person in Hollywood. And he became a person that was a gatekeeper to fame, riches, a career in Hollywood, what have you. It wasn't until October of 2017 that the New York Times and the New Yorker reported that more than a dozen women had accused Weinstein of sexually harassing, assaulting, or raping them. Many other women in the film industry subsequently reported similar experiences with Weinstein, who denied any non-consensual sex. As a result of those allegations, Weinstein was dismissed from his production company, suspended from the British Academy of Film and Television Arts, and expelled from the Academy of Motion Picture Arts and Sciences. He also resigned the Directors Guild of America and was denounced by leading figures, and all of a sudden the whole world was crumbling against him. The sexual abuse allegations precipitated a wave of national reckoning, launching very famously the Me Too movement. Roman Farrow had reported to the New Yorker in November of 2017, and Weinstein had hired British-Israeli private intelligence firm Black Cube in order to stop the publication of the abuse allegations against him, to no avail. Weinstein had reportedly sought help from Farrow's father, Woody Allen, go figure, to help stop Farrow from reporting on the claims of sexual abuse against Weinstein, and Allen declined help. Woody Allen had his own problems at the time. There was a documentary in 2019, The Untouchable. It was released with interviews from several accusers that were accusing him of various sexual assault allegations. And then finally, the New York County District Attorney's Office charged him formally with rape, criminal sex act, sex abuse, sexual misconduct for incidents involving two separate women. And on May of 25th of 2018, he was arrested that same day. They set a trial date for January 6th of 2020. And on that date, he was charged in LA with raping a woman, sexually assaulting another in 2013. The jury ultimately went to trial. The jury had deliberated for 5 days, convicted him in February 24th of 2020 of 2 of the 5 criminal charges, 1 count of criminal sexual assault in the first degree, 1 count of rape. In the third degree, the jury found him not guilty regarding predatory sexual assault, which could have led to a life sentence. He was remanded to jail at Rikers Island in New York City pending his sentencing hearing on March 11th, when he was sentenced to 23 years in prison. Subsequently, on June 2nd of 22, the New York State Court Appellate Division, First Department, upheld the verdicts and judgment on appeal. For the court's decision, Judge Mazzarelli wrote that we perceive no basis for reducing the sentence, and we have considered defendants' remaining arguments and find them unavailing. On August 25th of 2022, he was granted a further appeal before the New York Court of Appeals. It should be understood that on July 20th of 2021, he was flown out to LA. He was taken to Twin Towers Correctional Facility. They had a trial for him. That began in October of 22. He was subsequently charged with 11 counts of rape, forced oral copulation, sexual battery stemming from alleged acts between 2004 and 2013. He was found guilty on 3 of those 7 counts and sentenced to 16 years in prison. So why was his conviction overturned in New York, and what does that mean for Harvey? Well, for one thing, I have no qualms about saying that he is a proven sexual predator. He was found guilty in New York. They've overturned it. Fine, they're going to give him a new trial, whatever. He was convicted in LA. I'll tell you the reason why he was convicted or his conviction was overturned in New York, and it's a good thing, honestly. If you ever find yourself accused of a crime, one of the constitutional protections that you have that has borne out in case law and that has been upheld multiple times in federal courts, appellate courts, U.S. Supreme Court, and whatnot, is that the prosecution does not have the right to introduce what is deemed propensity evidence for the purpose of securing a conviction for crimes that you were charged for in a case. In other words, if you were charged with the crimes in a case, let's call it, assault with a deadly weapon with intent to commit great bodily injury or something to that effect, and you're charged and there's specific victims in that case, the prosecution cannot go back into your past for crimes that you were not charged of and bring witnesses to talk about, oh yeah, he did that once to me, because that's called propensity evidence. If it's somehow relevant to the current charges without being propensity evidence, which means, and all it means is he's done this before, he's going to do it again, he did it here, and since he did it before, he must be guilty of what he's being charged with now. You can't do that. It's not fair to anybody. If you have real evidence that you want to convict him on, then you need that relates to the current charges, then you have to do that. But if all it amounts to is propensity evidence, we're not going to allow that in. So for that reason, the Weinstein attorneys were arguing that there were multiple witnesses that were allowed to testify that he wasn't charged with anything. The statute had run on those claims apparently, and there was other things going on. And not to make this too long of a video, they basically were, the prosecution had these witnesses come in for the sole purpose of saying that he understood the nature of consent because he had been doing this to other people long ago. And so therefore, because he'd done it back then, he must have done it at this point. And up until now, that was fair game. The trial court said, yeah, sure, let those witnesses in, probably against her better judgment, but she did it anyway. For what reason? I don't know. But it was pretty close in the appellate decision. So there was obviously something to it. And this was essentially their argument was. So defendant argues that admission of the Molyneux witnesses' testimony. The Molyneux is a famous case that basically spawned a rule that the courts would use to define what propensity evidence was. But it says here, straight from the appellate opinion, Molyneux witnesses' testimony detailing sexual assaults he allegedly committed against them before and after the alleged offense conduct ran afoul of Molyneux and its progeny. We agree that this challenge has merit. Indeed, we reject the prosecution's theory accepted by the appellate division and the dissenters here that this testimony showed defendant's state of mind to use forcible compulsion against complainants and his understanding of their lack of consent. That analysis, if adopted, would eviscerate the time-tested rule against propensity evidence, which in criminal cases serves as a judicial bulwark against a guilty verdict based on supposition rather than proof on collateral matters or because of a defendant's past. And trust me, that is a good thing. Or on the defendant's bad character, and they allude to several different cases. And then they outline what the Molyneux rule is. So in Molyneux, the court reaffirmed that the general rule of evidence applicable to criminal trials is that the state cannot prove against a defendant any crime not alleged in the indictment, either as a foundation for a separate punishment or as aiding the proofs that they are guilty of the crime charged. The purpose of the rule is simple. Evidence of a defendant's uncharged crimes or prior misconduct is not admissible if it cannot logically be connected to some specific material issue in the case and tends only to demonstrate the defendant's propensity to commit the crime charged. The rule is the product of that same humane and enlightened public spirit which, speaking through our common law, has decreed that every person charged with the commission of a crime shall be protected by the presumption of innocence until they have been proven guilty beyond a reasonable doubt. To illustrate the universal acceptance of the rule and the reasons upon which it tests, Molyneux quoted its earlier decisions and those of other state courts. For example, the Molyneux court noted as far back as Coleman v. People, the court had explained, the general rule is against receiving evidence of another offense. A person cannot be convicted of one offense upon proof that they committed another. However persuasive in a moral point of view such evidence may be, it would be easier to believe a person guilty of one crime if it was known that they had committed another of a similar character or indeed of any character. But the injustice of such a rule in courts of justice is apparent. It would lead to convictions upon the particular charge made by proof of other acts in no way connected with it, and to uniting evidence of several offenses to produce conviction for a single one. And believe me when I say you do not want that kind of evidence to be allowed in if you are convicted of a crime? Well, obviously he was driving drunk because 20 years ago, back when he was 22 years old, he was coming home from a bachelorette party and he was stopped and he was found to have .11 BAC, but the cop let him go. He was supposed to be charged, but he wasn't for some kind of an error, but here it is. And they're using that to charge you as guilty as driving under the influence 22 years later. That would be an example of propensity evidence that would be ruled out. That is wholeheartedly not admissible according to all of these cases and is the basis for which they've decided to overturn this conviction. The court goes on to explain the impropriety of giving evidence showing that the accused has been guilty of other crimes merely for the purpose of thereby inferring their guilt of the crime for which they are on trial may be said to have been assumed and consistently maintained by the English courts ever since the common law has itself been in existence. Something like the 1400s or something like that. You're talking about 800 years of jurisprudence. Two antagonistic methods for the judicial investigation of crime and the conduct of criminal trials have existed for many years. One of these methods favors this kinds of evidence in order that the tribunal which is engaged in the trial of the accused may have the benefit of the light to be derived from a record of their whole past life, their tendencies, their natures, their associates, their practices, and in fine, all the facts which go to make up the life of a human being. This is the method which is pursued in France, and it is claimed that entire justice is more apt to be done where such course is pursued than where it is omitted. The common law of England, however, has adopted another, and so far as the party accused is concerned, a much more merciful doctrine. And by that law, the criminal is to be presumed innocent until their guilt is made to appear beyond a reasonable doubt to a jury of 12. In order to prove their guilt, it is not permitted to show their former character or to prove their guilt of other crimes merely for the purposes of raising a presumption that they who would commit them would be more apt to commit the crime in question in the future. So there is a two-part test, and it's pretty simple. And the appellate court goes on to state that, well, this kind of fails at the first part, but here's the test. If you're going to introduce a Molyneux witness, which is basically propensity evidence, then this is what you have to demonstrate. First, whether or not the prosecution has identified some issue other than mere criminal propensity to which the evidence is relevant. It could be for impeachment purposes. It could be to prove some element of the crime, but it can't just be because he only did it once, he's going to do it again. The second part of the test is if the evidence is relevant to an issue aside from propensity, the court determines whether its probative value exceeds the potential for prejudice resulting to the defendant. And very importantly, the court goes on to say this. It doesn't matter what way the court comes out on that. If you want to admit it, then fine. Give a reasoning. If you don't want to admit it, fine. But if you're going to admit it, you have to at least on the record have a discussion about it. Otherwise, there's going to be problems. This is what they say. The trial court's decision to admit the evidence may not be disturbed simply because a contrary determination could have been made or would have been reasonable. Rather, it must constitute an abuse of discretion as a matter of law. Basically stating that you're not going to penalize, you're not going to say the court is reasonable. Well, the court made the wrong decision, but it was reasonable to see the other side. If they made some kind of reasonable determination based on their discretion, then the appellate court's not going to touch that. But if it was a clear abuse of discretion such that no reasonable judge would have found that way, that's what an abuse of discretion means. So they're protecting the court's discretion in these cases. It goes on to say, however, any substantial doubt regarding how to strike a neat balance between possible prejudice to the defendant and indispensability of the challenged evidence to the prosecutor's case should weigh the scales in favor of the defendant, essentially stating if there's any doubts and you haven't had this discussion on the record, then they're going to side with the defendant more often than not. If the court concludes that the trial court abused its discretion by admitting Molyneux witnesses, the court must determine whether the error was harmless or requires a new trial. So that's in essence the rules by which they adopted. And here's why, in essence, they overturned it. Here, the Molyneux ruling fails at step one. The trial court admitted the evidence to show defendant's forcible intent when he had sexual relations with complainants. Rebut this claim of consent and explain why complainants were hesitant to report these assaults. Prosecution argues that the unusual nature of the entertainment industry and defendants' then outsized role in it, popular misconceptions about the behavior of sexual assault victims, and the complainant's acceptance of favors from him, and in one case, their continued consensual sexual relations with defendant following the assaults, rendered their testimonies equivocal on the issue of defendant's intent. Thus, the prosecution contends the trial court properly admitted the three Molyneux witnesses' testimonies to show his unlawful intent. We disagree, says the court, and conclude that as a matter of law, the trial court erroneously held that the prosecution showed that the Molyneux witnesses' testimony were necessary for a non-propensity purpose. First, the complainant's respective testimonies were not equivocal on the issue of consent. Complainant A described a violent, forcible sexual assault as well as her efforts to resist by kicking and pushing defendant. Complainant B testified that defendant physically blocked her attempt to leave the hotel room in March of 2013 and that when she did not comply with his demand that she undress, he grabbed her hand to force compliance. Complainant C testified that defendant lunged at her and that when she tried to walk away, defendant used his weight to lead her to the bedroom where she fell backward onto the bed. She tried to leave, but he pushed her back. He kicked and pushed to get away, but defendant used physical force to hold her down with her hands above her head and then forced himself on her as she cried and continued to say no. There is no equivocality regarding consent when a person says no to a sexual encounter, tries to leave, and attempts to physically resist their attacker before succumbing to the attacker's brute physical force. No reasonable person would understand such behavior as having communicated anything other than their rejection of sexual activity. Indeed, a contrary proposition perversely turns the concept of consent on its head. Simply put, there's nothing consensual about the conduct complainants described. And so far, they're saying that the prosecution's theory of why they needed those witnesses was nonsense. They're not coming there to discuss whether or not there was equivocations in consent, because what they described was essentially just straight up sexual assaults, where consent was really not at issue. As the appellate court says, no reasonable person is going to think that there was any kind of equivocations with consent there. That's why it failed. And then it continues. As the court has explained, where the crime requires the prosecution to prove forcible compulsion, if the intent required is the intent to perform the prohibited act, i.e. to forcibly compel another to engage in the sexual act, when it comes to Molyneux, evidence sought to be introduced to prove a defendant's intention in the crime charged, the probative balance has generally warranted admission of this evidence only where the acts involved in the crimes charged are equivocal, so that intention is not easily inferred from the acts alone. And they cite this 1969 case, People versus McKinney. In other words, evidence of prior criminal acts to prove intent will often be unnecessary and therefore should be precluded, even though marginally relevant, where intent may be easily inferred from the commission of the act itself. Where consent is not an issue, where consent cannot be equivocated, Molyneux, in this instance, those three witnesses should not have been admitted. That's why the court is overturning this conviction, and that's why they're going to have to retry these cases. In the New York case, basically starting from square one. And from my understanding, it appears that we got to do it again, then they're going to do it again. And they're going to do it without those prior witnesses and try to obtain a similar conviction. So that's where we stand on it. It's a good thing. Harvey Weinstein might be a creep. He may be, all the things, all the adjectives that you want to describe him to be in terms of whatever, his sexual misconduct, his creepiness, the ugliness of his conduct. He's all of those things. He has not been released from prison. He's still doing time on the LA conviction, of which he got 16 years. He's not going anywhere anytime soon. His health is failing. I'm not sure how much more time he has to go. But this is not the same as the Bill Cosby case, where Bill Cosby is, basically had his conviction overturned, and for a completely different reason, by the way. And he's sitting at home resting peacefully, not in jail at all. This is not that. It might have been that if it was not for the LA conviction, but indeed it is not. What this was a victory for criminal defendants, which may include you at some point. You never know. And it might not be. You think about, I'll never be convicted of a crime. You'll never know how crazy life could be where you may find yourself accused of things. But if you are, one of the things that you're protected against is they can't use stuff that you did in your past to prove crimes that you may have committed in the future. That's propensity. And that's all this is protecting and holding up. And as much as I don't like Harvey Weinstein, I agree with the legal reasoning behind it. So that's all I have for Harvey Weinstein. And again, this was an abbreviated version of the podcast on a Monday morning. I hope that you guys are all doing well at the beginning of the week. And for this next week's coming episode, I'm not sure if we are going to continue with Karen Reed or the Delphi murders or the Lori Vallow. Myself and Eliana are still up in the air about what we're going to cover on the long form podcast. So if you have any opinions, chime in, shoot me an email, comment down below, and then we'll see what we're going to do. But until then, I will see you guys later on. Bye-bye.